Hello everyone and welcome back to the Cell Court podcast. I'm Sophia Hurst and with me today is Gregor Hogan.
Hello there.
And today's episode we're going to be discussing two recent decisions on the interaction between the job retention scheme or furlough scheme and administration. Two decisions are in the matter of Carluccio Limited and in the matter of Debenhams. And without further ado, I'm going to hand over to Gregor.
Thank you, Sophia. Well, we're going to take the judgments sequentially. So the first in time was the Carluccio's decision, which is a decision of Mr. Justice Snowden about 2 weeks ago. The troubles of the Carluccio restaurants chain have been well documented in the press with its various ups and downs as it's tried to react to the changes in the restaurant market over the past few years. However, the impact of the government's lockdown, which required all of Carluccio's venues to be closed from the 16th of March, I think was the final nail in the coffin as far as the restaurant chain was concerned, and it may well have been the first actual casualty, economically, of the coronavirus in the UK. Unsurprisingly, it entered administration on the 30th of March this year, which meant that the 13th of April was the last day of the initial safe period that administrators enjoy when they can interact with employees, make use of their services, without having been taken to have adopted those contracts of employment. What became clear from the judgment was that the administrator's strategy was simply to mothball the Carluccio's business with the aim of selling the business pursuant to the aim under paragraph 3.1b of Schedule B1 to the Insolvency Act. But what was crucial to that scheme was that the administrators were able to retain the business's employees, waiters, bartenders, chefs, rather than making them redundant. But the administrators were only willing to do so if the employees' salaries would be met from the government's furlough scheme, thereby avoiding any further liabilities accruing to the business. Now, I'm sure we're all aware, but a quick recap. The terms of the government's job retention scheme, or as it's become known, the furlough scheme, are that the government will cover up to 80% of retained workers' salaries for up to £2,500 per month. But during that time, employees are not able to offer any services to the business or do any economically generating activity during that time. Payments to those businesses from the government scheme to cover the salaries are to be treated as income, and the employer must pay all of the grant received to the furloughed employee as their gross pay. Interestingly, the scheme guidance confirms that it should apply to companies in administration, but the government, and I quote, would expect an administrator would only access the scheme if there is a reasonable prospect of rehiring the workers. Mr. Justice Snowden considered that what that really meant was that the employees would be retained by the buyer of the business once it was rescued. Shortly after the administration order, the administrators had written to the employees informing them that the company intended to place them on furlough, but invited them to agree to a variation of their terms of employment, so their salaries would be capped at the 80% figure. Over 95% of the 1,788 employees accepted the offer, only 4 had rejected it, and there were 77 non-responsive employees. The real issue for the administrators, however, was that the furlough scheme clearly states that payments under it are to be accounted for as income, and as such would ordinarily constitute assets of the company administration, which then have to be dealt with in the order of priorities in the insolvency legislation. There was no suggestion, Mr. Justice Snowden held, and I think it's quite clear from the terms of the government guidance, that the sums were being advanced by the government to distress companies on a sort of quis-close trust type arrangement. The administrators therefore sought directions from the court as to whether they could rely on the super priority provisions related to employees in paragraph 99.5 of the Schedule B1 of the Insolvency Act. What that provides, as by way of refresher, is that payments of salary or wages due under a contract of employment adopted by the administrators shall be paid in priority to the administrator's own expenses, claims of floating charge creditors, and unsecured creditors. So they sit at the very top of the insolvency waterfall. Mr. Justice Snowden went on to provide directions in the form sought by the administrators. First, he held that the letters which had been sent by the administrators had effectively varied the contracts of those employees who'd accepted their offer. That was crucial for the administrators because that finding meant that there could be no question of them having adopted a contract for the full value of the employees' salaries. That thereby avoided the potential of any additional liabilities accruing to the business beyond the guaranteed furlough payments. Secondly, Mr. Justice Snowden concluded that the varied contracts would be adopted by the administrators within the meaning of paragraph 99.5, relying on the judgment of Lord Brown Wilkinson in the Powderall case, as and when the administrators either made an application under the furlough scheme or made payments pursuant to the varied contracts, which would then be reimbursed by the government's payments. A mere failure to terminate a contract of employment, of course, cannot amount to an adoption of a contract, but once the application for the furlough grants were made, Mr Justice Snowden held that would only be explicable on the basis that the administrators were electing to treat the varied contracts as giving rise to liabilities which qualify for super priority. Finally, the consequence of that was that the making of an application under the furlough grants scheme would enable the administrators to make super priority payments outside the ordinary insolvency waterfall, thereby insulating the administrators from any possible criticism. So it's, I think, a very useful decision, Sophia, from Mr Justice Snowden, clarifying that the government's coronavirus response measures are available to distressed companies and companies which are in formal insolvency proceedings. But as matters turned out, that another set of administrators came back to ask the court for further guidance, which is the decision in Debenhams, which I think you're going to talk us through now.
Yes, so barely a week later, another set of administrators applied under the same paragraph for directions. These are the administrators of Debenhams, which had been appointed by the directors of Debenhams on the 9th of April. And they made an urgent application on the basis that they needed to make a decision in the next few days as to whether or not to dismiss a significant number of the company's employees. So they also sought directions, and the terms of the declaration that they wanted was for the court to declare that none of the contracts of employees who had been furloughed would be adopted by the joint administrators, so long as they took no further action in relation to those employees except for issuing communications as may be required and for paying across the 80% of their salary under the furlough scheme. So the key difference with Carluccio's was, one, that these employees had already been furloughed prior to the administrators being appointed, but also that there was no agreement along the lines that you outlined, Gregor, in Carluccio's. There was no agreement with employees that they would forego the extra 20% of their salary. And so the application was made perhaps on the slightly unattractive argument that if, as was effectively conceded in the Debenhams application, if employment contracts payments under the furlough scheme had super priority for the purposes of the administration, then the fact that the company would be liable to pay the extra 20% in addition meant that it would have a significant effect on the future conduct of the administration, because packaging that up as a going concern was going to be almost impossible. And so the administrators would be forced to instead make a large amount of redundancies. I think it's worth noting at the outset, again, and similarly to Carluccio's, that Mr Justice Trower didn't feel able to make a firm declaration as to the legal effect of the relevant provisions, in part because there had been no argument from the employees or the government as to the effect of the scheme. So similarly to the Carluccio's decision, what we have instead is a general confirmation that the administrators are at liberty to conduct themselves on the basis of what Mr Justice Trower thinks the effect of the law is, rather than a formal declaration. But I think that notwithstanding, the weight of the two decisions put together leaves matters pretty clear. So again, adopting the argument that was put forward in Carluccio's, in Debenhams it was confirmed that what Lord Brown Wilkinson said in Powder was absolutely right, that positive conduct is required by the administrators to affirm or cause the relevant employment contracts to be continued, but that would certainly be the case if the administrators continued to pay out under the furlough scheme. So Mr Justice Trower was pretty clear that by causing the company to apply under the job retention scheme and make payments to the furloughed employees, that they would be engaging in that positive conduct. And it would not be possible for administrators to participate in the furlough without having elected to treat those contracts as continuing. And then, as I say, it was effectively admitted that the effect of that would be super priority in respect of those liabilities. Now, there was an argument raised by counsel in the Debenhams application that the effect of, if that was right, if that was the law, then that would undermine the job retention scheme, because it was effectively forcing Debenhams to make people redundant by virtue of the fact that the employees would have super priority under the administration. Mr. Justice Trower gave that pretty short shrift and said that although the policy of the job retention scheme might be undermined if administrators adopting contracts would lead to more employees being dismissed than would otherwise be the case, that hadn't been established on the evidence, and that the mere fact that the scheme was designed to try and prevent redundancies during the pandemic could not of itself be a reason for the court finding that the contract hadn't been adopted, if that would otherwise be the consequence of the established principles in the Powdrill case and all of the relevant guidance on that. So arguments around the policy of the job retention scheme weren't ultimately persuasive. So I think where that leaves us is we've got a pretty clear confirmation of the way in which payments under the job retention scheme will be treated by administrators, which is helpful. But given the sorts of arguments that were raised about actually ultimately this resulting in more redundancies and so on, there is a little bit of a sense, perhaps, that comes into the wider criticisms of the policy of the furlough scheme. There's a bit of a sense of kicking the can down the road. Gregor, I don't know what you make of that and the consequences of the two decisions.
Yes, I mean, what was quite interesting was that the commentary of Mr. Justice Trower about the nature of the administration that was taking place in Debenhams. The administrator's evidence had described it as quote, a light touch administration, which has come to be known in the industry as effectively where the administrators step in effectively to assist with the financial restructuring, but leave and delegate most of the management of the business to the existing management structure. And, you know, there is a real question as to if those sorts of administrators are saying that the effect of the government scheme and paragraph 99 of Schedule B1 would be that the very purpose of that administration would be undermined because you effectively have to make people redundant, which then means that the business is worth less as a going concern, which may mean that therefore the whole purposes of administration can't be achieved. There is a real question as to whether this has any real medium-term or long-term benefits. Most of the government, I think it's widely accepted within those who practice in the field of insolvency that a lot of the government's measures are effectively pressing the pause on inevitable insolvencies, and nobody really quite knows how that's going to play out. I think another interesting point that was canvassed in both cases was whether you could rely on paragraph 66 of Schedule B1 instead of paragraph 99.5. Schedule 66 is a kind of catch-all paragraph allowing administrators to make payments otherwise than in accordance with the prescribed order of priorities in the legislation. Both Mr. Justice Snowden and Mr. Justice Trower didn't discount the possibility that payments could be made to employees under those provisions, but what they both concluded was that the natural starting point when considering employee payments was paragraph 99.5. And Mr. Justice Trower went further. He said, once you have engaged the adoption principle in paragraph 99, you can't then turn around and say, well, in fact, I don't really want to adopt the contracts of employment. I want to use paragraph 66 instead. He said it is an objective test. And I think that's an interesting point as well, because it's not offering a great deal of flexibility to administrators. But then that was a criticism that Lord Brown-Wilkinson made of original paragraph 19, which is materially the same form as paragraph 99 under the preceding legislation. He said this effectively ties administrators' hands. And Parliament's had, 20 years to update the legislation? It could have done so when Schedule B1 was introduced, but it has chosen not to. So I think administrators are kind of stuck with the strictures of the regime.
Absolutely, and I think the clear message from both of these decisions is that this is a question that's at all fours with the established case law and the test of the meaning of the word adopted and how that was interpreted by Lord Brown-Wilkinson in the Powdrill case. So very little wiggle room allowed. Although it is worth noting, and Mr. Justice Trower does note in his judgment that there was some regret in Lord Brown-Wilkinson's judgment as to the policy behind the new super priority law. And even at that time, he noted that the solution from Parliament of affording super priority had thrown up a consequence which was, he said, inimical to the rescue culture. And one can have some sympathy with the applicants in Debenhams trying to push that argument, but unfortunately it seems that we're pretty clearly bound by the House of Lords authority in power drill unless and until Parliament rethinks this particular issue, whether that's by way of temporary legislation in the context of COVID or more generally. But against that problem, in terms of practical guidance going forward, I think something that you raised at the very outset, pretty clear that if administrators are coming to this kind of scenario within the 14-day safe period, perhaps one of the most important things that they can be doing is trying to seek employee consent to vary the contract so as to limit the company's liability for the 80% that's going to be covered under the government scheme, so that these sorts of problems don't arise.
Yes, I completely agree, Sophia. Well, I think we've bottomed out those two decisions. Thank you to all of you for joining us, and I think that's goodbye from me and goodbye from Sophia.
Bye.